Or have I stunned you into silence? It's a lot to digest. And not all of it is positive, yes.
Yeah, I had a question on what you meant by the concurring opinions and the havoc they cause. So are you saying that there's a decision made and people are agreeing with it, but for different reasons and different parts and, yeah, could you just
So
explain?
the question is about these concurring opinions and what is the problem with them? Well, it's as you said, the justices that are filing concurring opinions agree with the outcome that the majority has ruled, but they may have different reasons for getting there, or they may have wanted to make the decision broader in some ways. And so they map out their own little preferences. And as I said, this is a problem because lower courts kind of struggle with these things, trying to figure out whether a certain thing that a concurring opinion has said is an amplification of and part of the majority decision, or whether it's just a frolic and detour by that particular justice. Yes, in front here, and then we'll go behind.
First of all, thank you very much for an extremely interesting and comprehensive overview that none of us, or I certainly wouldn't have the time or resources to delve into.
Thank you.
Could you please explain a little bit more about the significance of the Colorado ballot unanimous decision?
The Colorado ballot unanimous decision. Again, this is an uncharted part of our Constitution, the third section of the 14th Amendment. And Colorado had taken the position that it could exclude a candidate from the ballot because Colorado concluded that that candidate had engaged in an insurrection or rebellion. And so the court said, we're not going to have the states making those decisions, even though states generally have a lot of discretion about how they handle elections. But when it's an interpretation of the constitutional provision, the third section of the 14th Amendment, the court said, that's our territory, and we say Congress has to decide that. So my comment about the decision was they didn't really tell Congress how they should go about doing that, whether it's part of an impeachment process or whether there's some other kind of action that Congress is supposed to take to interpret the Section 3 of the 14th Amendment. Mm-hmm. And then, yes.
So to clarify, the person that in the Colorado lawsuit was a person who lived in Colorado?
No, it was President-elect Trump. The Colorado authorities had concluded that his name should not be placed on the ballot. And the court said, can't do that. Yes, in the back.
And to add on to that, if I'm correct, it was a person who brought the case forward, an older woman who said, this is not going to happen. And I believe she had been a lifelong Republican, but became an activist because of it, and then brought this case to the Colorado court.
So she was the one who got the Colorado election officials to exclude the Trump name from the ballot. Interesting. Yes.
So with these concurrences and things like with what Justice Thomas did with inferring that there could be another aspect for other people to bring things before the court, doesn't it seem that it kind of goes with the ethical aspect of it, that they're signaling, well, like what he did about gay marriage and I think even interracial, that he, infers that this might be something to consider. It just seems to go along with the whole ethics aspect that they are telegraphing these two, and it seems like
interesting comment, so if you couldn't hear. The question has to do with the concurring opinions again, and my comment that Justice Thomas is particularly well known for sending signals to litigants about what kind of cases he would like to see. And the question was, isn't that an ethical violation? I don't see it that way, because the cases that, the way he expresses it would be something like, we ruled today that capital punishment is not prohibited by the 8th Amendment. But I think it's time that we took a closer look at this, or so, I'm making that up just to give you an example. So it's always expressed as legal issues, not pertaining to, let's say, particular litigants or people with an interest in the outcome of the case. Does that help clarify it a bit?
It's a nagging feeling that I have.
Nagging feeling
Yeah.
that you have about
But
Justice
sure.
Thomas.
Especially him, and it does go with previous court cases because of gay marriage and interracial marriage, that, you know, he's putting something.
It wasn't, I mean, he's an interracial marriage, it was more, I think the question he was raising,
Well,
the question he
I-
was raising was about birth control. I think with his latest thing, when he signaled,
Was about birth control.
yeah, he was throwing that out there, that maybe this is even open to whether people have access to birth control.
I think a lot of people are waiting for the other shoe to drop as a follow-on to the Dobbs decision, overturning Roe v. Wade, because Roe v. Wade, as you will recall, was based upon the idea that there is a right to privacy inherent in the Constitution, although not expressly stated in the Constitution. And so there are a number of other cases that have been decided by the Supreme Court involving the implied right of privacy, including things like interracial marriage, the ability to engage in sexual intercourse outside of marriage, the ability to use contraceptives, and there's a long list of sort of penumbra issues. And while the court said in the Dobbs case that they weren't addressing any of them, that doesn't mean that they can't address them later. Yes.
I have something that's been bugging me as well. The Supreme Court is supposed to be interpreting our Constitution. Where did they possibly come up with the immunity decision?
Thank you. So I'm so glad you asked that question, but I'm not going to be able to answer it.
Can you repeat the question?
So the comment was, well, the Supreme Court is charged with the responsibility of interpreting our Constitution. Where did they come up with the presidential immunity decision? And that is a very controversial thing. I mean, they really reached for it, and there were so many ways that they could have circumscribed it, narrowed it, and so forth, that they really went whole hog, including the ability to preclude civil juries from hearing issues involving presidential acts. I can't tell you what the foundational constitutional law basis for it is, but I think that the court was thinking that constant litigation against a president would hamstring the president's ability to do the president's job. And there certainly is, that if that were to occur, that certainly would be an issue. I think that the justices who were on the other side of it were worried about the ability of a president to violate the law with impunity. And certainly the phrases and contours of the decision mean that the court itself, as I said, will be the one to decide in each case. So they've really created a situation where they and they alone can make the final decision, because it can be expected that pretty much any case involving presidential immunity will be appealed to the Supreme Court, and they'll probably take the case.
But that only applies for the president's action while he or she are in office, correct?
Yes, it does, but for example, in the New York case, many of the actions that were sent to the jury were that of a candidate, not a president. So I'm just saying, where is the line drawn? Yes?
Is there any good news?
I wish I had good news to share, but I'll give you a couple of things. I mentioned Justice Barrett's voice. I find that quite, now that's not to say that she's becoming a liberal, or even that she's becoming a centrist or a swing voter. She's definitely conservative, but she is looking at principles and struggling with them, and I admire that, and I think that's a very healthy thing for the court. The other thing that I would say that's hopeful, and this may be way out there, but a few years ago, this court created a new doctrine that they just sort of made up called the Major Questions Doctrine. And in it, they said, well, if a federal agency comes up with a ruling that is so newly different from anything that was indicated that they could do before, and it's an important issue, that the court can simply say that an agency can't do that. It has to be something that's done by Congress. So here is a principle that the court has used in the past, mostly to strike down progressive positions. But all I'm saying is that one can imagine that if the court decides that they're the ones to put the brakes on a new administration, that would be a handy doctrine to use. So anyway, watch for the Major Questions Doctrine. And we'll check in next year and see if anything has happened. Yes?
Well, if you can't enforce what the Supreme Court decides, can a federal agency like a state say, hey, I'm not gonna do that?
So the question is, if the court has no enforcement functions, and it does not, what would preclude a state from simply saying we're gonna go our own way?
Or a federal agency?
Or a federal agency? Yeah, I think I see it more as a state, a risk that a state would strike out on their own on an issue like immigration or criminal law or something like that. A federal agency, less likely. But then we're about to see a possibility that federal agencies will be
Dismantled.
well, it changed in fundamental ways, so maybe I should say, I don't know what to predict. Yeah.
A state like California could say, we're not going to enforce the immigration law.
Or a state like Texas would say, we're going to make up our own laws and enforce them stringently.
Well,
Yes,
California could do the same thing,
either way.
and it just depends on whether you want to swing left or right, but
That's,
it's a possibility, so it's another form almost like secession.
well, this is raising that we should use the secession word. And this is fascinating because really this is, we're getting to the very fundamental question of what does our Constitution mean and what have we all agreed to when buying into it. And so secession or nullification was another term that was used prior to the Civil War. That is the idea that states could decide not to follow federal laws. I saw a hand in the back there.
What do you know about or hear rumors about, this is totally different, the collegiality amongst the judges? I know in the past, and I think I've heard you talk about it maybe 3, 4, 5 years ago, there was a good sense of collegiality amongst the judges or some of the judges. Do you know anything about what's happening with this very partisan group?
So the question is, what do we know about the collegiality on the court? And in the past, we've heard stories about how Justice Ginsburg and Justice Scalia used to go to the opera together and that sort of thing. I have no specifics other than the things that I mentioned about dissents and so forth. But I feel that it has disintegrated or deteriorated is a better word, over the last few years. I think that I can't imagine what it must be like for all of the justices, but especially the liberal justices, to get up and go into work every day knowing how little influence they're likely to have. And that must be extremely discouraging. Maybe for some of them it's really just gets their juices going, and let's hope that they'll keep going. I'm sorry, I'm supposed to be non-partisan, but I'm flunking that test. Sorry. Yeah, but I do think there's friction and difficulty, and it's affecting the way they work together. Cindy?
Yeah, I was curious, what opportunities are there to reform the structure of the Supreme Court? I mean, could Biden have said, we're gonna increase the number of justices, and he could have appointed somebody?
So the question is, what about court reform, and can a president appoint additional judges and so forth? So to expand the number of justices on the court would require an act of Congress. So the president cannot do that unilaterally. I think that my comments about the workings of the court suggest that they could use some more help. But I'd rather not have 2 more of this. But looking at the sort of ideological balance on the court, the idea is that a president who controls Congress could restore the balance to that president's preferred position by adding justices. But then the next time that there's a change of administration and the Congress is amenable, then more would be added. It's like a dog chasing its tail, and pretty soon you have an unworkable number on the court. The other proposals that have legs, I think, is the idea of term limits. And this, as I mentioned, is very popular and has a lot of things to recommend it. By making every president able to appoint 2 justices during each 4-year term, it means that the ideological makeup of the court over time would kind of match that of the electoral college, let's say, maybe not the popular vote. And that would be a way of moderating things. I also like the idea of creating a senior justice status that termed out justices could stay as senior justices. They'd be paid the same amount, they'd have all the privileges, they could use the basketball court at the court and stuff like that. And they could do two things. If a justice had to recuse him or herself because of a conflict, that senior justice could step in to act as a justice in a specific case. Second thing is, if we had a group of these senior justices, I think they could be the authority that would impose ethics rules on the other justices. And so it would be more like their peers being in judgment on them. So I think that would be an interesting way to use them. But again, we'll take at least an act of Congress, and this Congress coming up will have no incentive whatsoever to either add justices or impose term limits. I think we're getting a signal that it's time to wrap up. These have been great questions. I really enjoyed being with you tonight. Thank you very much.